All right, welcome back. So this is going to be quicker. This is the last part of Chapter 4 on jurisdiction. Most of the things that you have to remember I emphasized in the previous capsule, so there isn't really anything to add there. You'll see that you have, so second portion of it, page 206, sorry, and following, you have a historical review of the standard of review that applied to jurisdictional issues in administrative law. Of course, most of this is helpful in understanding how we got to what you learned in the previous capsule, why the Supreme Court in Vavilov in 2019 decided to eliminate the separate category of quote-unquote true jurisdictional issues, which were up to then subject to a different standard of review, which is correctness. As we said, the Supreme Court didn't necessarily change the substance of what it was saying as much as it clarified it, because now the rule is that the category, as we said, doesn't exist anymore. And so it's subject to the default standard of reasonableness review on a jurisdictional issue as well, unless it's subject to one of the exceptions, right? And the exceptions are framed somewhat narrowly. We mentioned them. There's actually 5 total that subject something to correctness review, not 5 on jurisdiction, 5 total in Vavilov. We mentioned them briefly in the previous capsule. And these can include, right, jurisdictional issues that are in the sense that I described in the previous capsule, where essentially there is a single possible interpretation to a statute, and it's generally an issue as to, right, someone just exercising a power that they don't have, and that being, right, very objective on the face of the statute. You see how that evolved with the historical review. Of course, most of the precedents don't apply anymore, but you see how, right, the initial intent was to draw that distinction that I've just described, but as it went forward, right, people were claiming more and more issues as being true jurisdictional issues and trying to subject these to correctness review, which, as we said, right, there's strategical reasons for. If you're the lawyer, you want a less deferential, the lawyer challenging a decision, you want a less deferential standard to apply because that will get the decision quashed, and that's what you want when you're seeking judicial review. And eventually, right, lots of jurisdictional issues were being subjected to correctness review, and the court clarified that by saying that, right, essentially what I said in previous capsule, most jurisdictional issues are not that. They are jurisdictional issues where there is no clear answer, where you're interpreting a statute that's often purposely broad. The power of the administrative entity is purposefully broad, and therefore, right, the interpretive exercise is part of what you expect them to do. And in fact, right, it's necessary to ascertain what they are able to do. And therefore, the court said, right, we'll simplify things and reiterate that the default standard is reasonableness review, which means that if you're trying to have a more stringent standard apply, you will have to show that you fall under one of the exceptions. Otherwise, it's presumptively subject to reasonableness review, and that, in practice, is going to remove, right, a lot of debate in court as to the parties trying to say that that things are subject to correctness review. There's a brief mention in the section of patent unreasonableness, which is something I want you to forget about. It's an old standard, it's extremely confusing, and it doesn't exist anymore for our purposes. So for our purposes, you can forget that. I tried to remove the portions of the book that talk about that standard, because I think the two that we have, especially given the fact that they significantly changed recently with Vavilov, are complicated enough, and I don't want you to get confused with that. So whenever you see patent unreasonableness, don't worry about it and act as if it wasn't there. 210, there's a brief mention of something somewhat interesting, which is that, and this is not law, right, but that perhaps courts apply a standard on a spectrum. And we saw that with things like procedural fairness protections. We said, right, the Supreme Court said there's no actual standard. It's neither correctness review nor reasonableness review. And you look at whether the procedural protections were met, which are going to depend on, right, the nature of the decision being made. If it's a decision that has a big impact on a person's life, then you'll have lots of procedural protections, and the court, upon judicial review, will be more stringent in reviewing whether these protections were met. Other end of the spectrum, it's the opposite, right? There is a mention in both sections of the chapter that perhaps this happens with the other standards of review as well. So even though there's technically two, right, there's correctness, there's reasonableness, they're really different in the way we described, perhaps court are actually applying these standards, right, in a way that is proportionate to what they are reviewing. So perhaps sometimes they're saying it's reasonableness, but because they have to, right, because that's what the law says. The Supreme Court said that in Vavilov, they've got to do that, right? They can't, on a lower instance court can't just start redefining the standard there. But they will apply reasonableness, which is technically the same standard, more or less stringently, depending upon the seriousness of what they're trying to review. That's purely speculative. I think it's correct, right? But that's mentioned in a number of the commentaries that you have cited in the book. 213, we reiterate what I mentioned earlier, which is that, right, we looked at Vavilov, we quoted verbatim from Vavilov, and we said that the Supreme Court said that the specialized expertise of a tribunal doesn't just mean that we defer to it upon judicial review in allowing it to make a decision that perhaps the court would not have made because, right, we assume that there's reason for it because it has specialized expertise, and that's the underlying intent of the legislature, etc., right? That applies more broadly. We saw that previously. So it applies to the fact that they might not have to have a decision on something that looks like a court decision. It could be short, it could not be in writing, could be written in a weird way, could be citing weird stuff that doesn't seem to have legal importance. And it applies to, for the same reasons again, the statutory interpretation exercise as well. And so the court can think that the way in which an administrative tribunal came to a jurisdictional answer, right, interpretation, decision, is weird. That it is not consistent with the traditional principles of statutory interpretation, that it is framed in a way that's weird, it cites stuff that's weird, and that is allowed because you'll recall, right, the direct quote I gave you from Vavilov, the Supreme Court even says that enriches the exercise of administrative decision making. That's reiterated at page 213, and it will apply to issues of interpretation as to a jurisdictional issue as well, because, as I just said, right, it applies more broadly. That's why, if it wasn't clear already, right, that's why you have deference, right, to the extent that exercise is going to be different, the court perhaps is going to not understand it, right, and think that it would have made a different decision when in reality, right, there's a justification for that way to reason or way to make a decision that the court doesn't fully see or understand because it doesn't have that expertise, isn't in the situation of the decision maker, right, seeing these cases every day. Something that's mentioned explicitly, notably in Human Rights Commission, page 215, is that, again, you've got the presumption of reasonableness. So by default, it is that. But it's the court has reiterated before that it's even likelier to be reasonableness when the decision maker is interpreting their own statute. And that makes sense, right? It makes sense based on the things that we've seen, right? The statute that creates decision maker with specialized expertise, of course, that decision maker is going to be expected to apply its own statute. That's what it was created for, right? So say the statute's going to say you have the power to award compensation. Well, then, of course, you just created an entity to award compensation. You will expect it to interpret what the word compensation means, right? And that's just a statutory exercise that we see all the time, and that's necessary because words don't speak for themselves, especially when it's a five-word sentence in a statute, right? So you'd expect that to be within the expertise of the decision maker or entity, and therefore to be, right, subject to more deferential judicial review, as opposed to, say, some other statute. 215 and 16, you see an example of what I said, right? I said the parties are always going to claim that one of the exceptions for correctness review applies. And you see that there, right? You see a claim that some pretty simple issue of statutory interpretation, basically the example I gave you, right? I think it's the interpretation of the word cost or expenses, that is a fundamental human rights issue, right? Or an issue, per Vavilov, of central importance to the legal system as a whole. And it's easy to claim, but rarely will succeed. And that's one of the, again, exceptions that we briefly saw. And so if you have an issue of statutory interpretation, it's subject presumptively to reasonableness review, because, right, Vavilov says everything is subject to reasonableness review, and it says explicitly that that includes jurisdictional issues. Then, right, the parties can still claim one of the recognized exceptions. We said one of them is an issue of central importance to the legal system as a whole, and we said that that's the broadest exception. Well, you can claim that, of course, on a jurisdictional issue. You can say that a jurisdictional issue is of fundamental importance to the legal system as a whole. So you can say it removes stuff from the superior courts, that's outrageous, and you'll have a bunch of bureaucrats who don't know what they're doing, therefore it's of central importance to the legal system as a whole. Or you could say this interpretation will have a persuasive impact on 1,000 future decision makers, and therefore it's of central importance to the legal system as a whole, and you want that to be made by a court, right? Again, that claim will often be made, but rarely succeed. And that will be the end of our review of Chapter 4.